So anyways, I've been here a long time. When I started, I said, oh, this is a job, I'll be here maybe 3 years. So, 22 years after that, I'm still there. I got some questions. I figured a good way to get us started, and then we'll kind of open it up from there, because 7 questions, I'll take about 7 minutes, maybe. Okay, well, about the first time. Okay, so the first one is, short sellers canceling while in escrow. Isn't there a legally binding contract? Right? The answer is, well, there should be. There should be a legally binding contract. Okay, so let's go through it. Buyer makes an offer on a short sale property. What should happen is the seller needs to accept the offer. If there's more than one, hopefully the seller accepts just one. Maybe put sellers in backup position. So the seller accepts an offer. That creates a binding agreement right then and there. When you're making an offer on short sale property, you should always use the short sale addendum along with the purchase addendum. When you use the short sale addendum, what does that do? Short sale addendum says, aha, this contract, because we now have a binding contract, this contract is contingent upon the seller's lender's approval. Right? So you have a binding contract with a contingency. Pretty big contingency, but still a binding, enforceable contract. Security contingency. Now the short sale addendum says what? The very first paragraph of the short sale addendum says, this contract is contingent upon seller's lender's approval. And I'll just use the default language. It says within 45 days. Some people make it longer. I rarely hear of anybody making that time shorter, but the default time is 45 days. When the buyer makes an offer on short sale property, the buyer is essentially telling the seller, I'm going to give you 45 days to get your lender to approve. So I'm actually answer a question which wasn't on here, which is, we often get the question, what about the buyer who now wants to back out? On day 5 or day 10 or day 41, before that default period has expired. Does the buyer have the contractual right to back out based on the short sale addendum? The answer is no. The buyer is giving the seller that full period of time to get the lender's approval. Okay. Do I need to stand in one place? It's not video recording. Okay. Yeah, it's hard for me to stand still. So a lot of times we'll get buyers who back out because, guess what? You got some buyers who say, hey, you know what? I'm going to make offers on 10 different short sale properties, and when I find one that I really like, I'll go with that one. I'll just cancel all the other ones because who cares? Well, who cares? The sellers care. The seller's lenders care. The listing brokers care. All right? And even the brokers who are representing the buyers care. So can buyers contractually get out of that contract before the 45 days is up? Well, not based on the short sale addendum. No, we've got to be honest with you. We all know it's not difficult for a buyer to get out of a regular contract during a contingency period. Not difficult for the buyer to find something the buyer does not like. It's very hard to contest. It's very hard to show the buyer's acting in bad faith. So, if a buyer gets out before that 45 days is up, the buyer really cannot use the short sale addendum as an excuse to get out. Can the buyer use some other reason as an excuse to get out? Possibly. Maybe the buyer has done their own investigation of the property that they didn't do before making the offer. And now they'll find out, it's too close to a school, too far from a school, too noisy, too quiet, whatever it is. Something that's hard to actually contest that the buyer's acting in bad faith. Now, I've had some people tell me, well, buyer, you can't use that as an excuse until after the 45 days. Then your contingency period starts, the way the default language is. Now your contingency period starts. If you've got a legitimate excuse to get out, now you can get out. And the answer to that is, first off, you're representing the seller. Why do you want to wait for them? Wouldn't you rather know earlier? You could start marketing the property or go to one of your backup buyers. And there is a maxim in California law that basically says the law does not require futile acts. So if you have a legitimate contractual reason to get out, again, focusing on legitimate, why do you have to wait until after the 45 days to then exercise your legitimate reason to get out? You don't really be harmed if you have a legitimate reason to get out and you're exercising that early. Okay? But see, some people say, well, wait a minute, we've got the short sale addendum, we can get out any time in the 45 days. That's not true. The short sale addendum says you're going to give the seller 45 days to try to get the lender's approval. So now, let's say we are past the 45 days. If the lender does not approve, then either side can cancel, not a problem. You have a binding contract, either side can cancel, buyer or seller. That question you have to do with the seller. Now let's say we're at sometime during the 45 days, the lender approves. Okay? And let's just make it, for the sake of argument, real easy. The lender approved the offer exactly as written, so we're not going back to the buyer and changing terms with the contract. Okay? Well, guess what? That contingency has been fulfilled. Buyer or seller cannot get out based on that short sale addendum contingency anymore. It has already been fulfilled. Okay? And now let's say, which I think I'm reading into the question here, the buyer does not want to get out. Have an enforceable contract, the contingency has been fulfilled, the buyer wants to move forward, and lo and behold, the seller, while continuing to discuss this property with the lender, says, you know what, the lender has finally conceded to a loan modification. All right, maybe they're giving us some principal, maybe they're changing the terms, maybe they're changing the interest rate, whatever it is. The lender has finally conceded to the seller, says, I don't want to sell anymore. Or maybe you have a seller who says, I've been talking to a lawyer, I've been listening to the radio. And if I sell, geez, I didn't have to get out of this property in 30 days. But I could probably hang in here for another 6 months to a year. So maybe I really don't want to sell. Okay? So I'm just going to cancel with the buyer. The short sale addendum contingency is not valid anymore. As a seller, there's no contingency that I have as a seller that's going to let me out of the property. Am I in breach of contract? And the answer is absolutely yes. And then we get to the real big question. The two-word question. And you were close. Because I say, so what? The seller's in breach of contract. So what? Buyer, what are you going to do about it? Okay, buyer, normally there's two things you can do when a seller does not sell, when the seller is in breach of contract. You could sue the seller for specific performance or for damages. And what does specific performance mean? You want the property. That's basically worthless in the case of a short sale. Because the buyer, you can file a lawsuit against the seller for specific performance. You can place a live pendants on the property so the seller can't sell it to anybody else. What's that going to get you? Nothing. The seller will just continue not to make payments. The lender will foreclose. Even if you recorded a live pendants, the foreclosure will wipe out your live pendants, and you've got nothing if you're a buyer. So you say, well, I'm not going to bother with specific performance. I'm going to go after the seller for my damages. Great. Go after the seller for your damages. If you're suing somebody, and let's assume it's not an investor. Let's say it's just a homeowner who's in default, who's trying to do a short sale. You're going to sue somebody who's losing their home and trying to collect damages from them. Now, you're absolutely legally in the right, buyer. You could be absolutely legally in the right, but is there any money that you're going to be able to get from that seller? And so we have to kind of weigh. There's the legal implications and there's the practical implications. And the practical implications of a seller who's in breach of a short sale contract are not a lot. The practical implications are you kind of take your lumps and you move on. Maybe you negotiate a little bit so at the very least, since the lender approved the sale and you probably had to, as a buyer, make your deposit, at the very least try and get your deposit back. Right? Because we've got a lot of problems with short sellers. They won't sign anything, releasing anything back to the buyer because the sellers don't care. Okay? And it has nothing to do with being mean or being evil. It has to do with the sellers are already burdened with too many things, a lot of the sellers. And it's just too much of a bother to get them to sign escrow instructions releasing a deposit. So if this happens, they say, yeah, buyer, you absolutely are legally 100% in the right. And you could spend $20,000, $30,000, $40,000 in attorney fees for the satisfaction of knowing that somebody else agrees with you that you're in the right. Or you can try and get your money back and move on. Okay? So, the question was simple. Is there an enforceable contract? Yes. As a practical matter, what do you do about it? Unfortunately, not a whole lot. That's just too bad, but that's the reality of the situation we're in right now. Gentlemen here, and then I'll go to you, Larry.
Ours got a little further along than that, and I've heard of it happening to others as well. Not only did the short sale get approved, but we had the appraisal done. We were getting ready to do a physical inspection. We were about 10 days away from closing. We had docs ready to go sign, and the seller just walked away from the property.
Okay, so the question here, for those listening at a later point in time, was, it was more than just lender approval. You're basically ready to close. You're a few days away from closing, and the seller refuses. The seller walks away. Does that change the analysis? Not at all. The seller is still in breach, just like the seller would have been in breach earlier. Buyer, what can you do about it? Okay? Now, a really great negotiator may get the seller to change his or her mind. And if you are that good of a negotiator, you should go in the Negotiators Hall of Fame. In the question we just got, it makes the story that much sadder. Right? Because the person is the buyer's been so much further invested in the property. They've had their appraisal, they've incurred additional costs, they've had inspections, they've had payments that they've made. They now have really high expectations that the transfer is going to go through. So emotionally it makes everything a lot worse. Legally it doesn't change a thing. And one just has to evaluate, is it worth it to pursue the seller or not? Is it worth it from a financial standpoint? Is it worth it from an emotional standpoint? And in almost every single case, unless you have an investor seller that has assets somewhere else, it's almost never worth it from a financial standpoint.
Can you go to small claims court?
Okay, question is, can you go to small claims court? Absolutely. Absolutely. What are you going to be suing for? If all you want to get back is your appraisal costs, your inspection fees, I think that's a very good route to go. And here's one reason why it's a great route to go. Okay? Especially starting this year, and if anybody sticks around at 12 o'clock, we'll talk about one of the new laws. Small claims court jurisdiction just got raised to $10,000. Okay? Effective January 1st of this year. So that's really good. That's a good thing. All right? You can get a judgment against the seller. Maybe the seller is down on his or her luck right now. That's why the property is going to foreclosure. That's why it's a short sale. Okay? Still, you go to small claims court. Hopefully the judge will listen to the law as opposed to sympathy. Okay? And hopefully you as the buyer will win. You can get a judgment against the seller. A judgment is good for 10 years. Maybe the seller's luck will change sometime in the future. You have a valid judgment that you can enforce against the seller's assets at a later point in time. Okay? You say, well, why just bother going to small claims court? Why not do the same thing in Superior Court? Because in Superior Court, you need a lawyer. Okay? And you could win your $3,000 or $5,000 or $10,000. It's going to cost you $30,000 to win it. So the small claims alternative is truly a viable alternative.
I was just going to mention, you can also use the leverage of the bank. If you've got an approval on a short sale, I have heard that through the listing agent or through the buyer's agent, but usually through the listing agent, contacting the bank and say, listen, on that short sale that you approved, the seller is now making the decision to back out of it. Would you like to take the extra step of calling them and talking to them and using whatever leverage you have to convince them to continue with the short sale? Because they can tell them what's going to happen if they don't continue with the short sale.
Okay, so what did Larry suggest? If this happened to you, contact the seller's lender. See if the seller's lender can put some leverage. Maybe the seller's lender informing the seller what the consequences are may help in the situation. And you said you've heard of that happening. Have you heard of it actually helping?
Yeah.
Okay, so we've heard of that actually helping, and that's really great.
What can the buyer's agent do to prevent the scenario that Mark was talking about?
Okay, what can the buyer's agent do to prevent the scenario? So I'm going to answer as a lawyer, and then somebody from the audience will answer as a realtor. Okay? As a lawyer, nothing. Okay? You can't prevent somebody from breaching a contract. Now, as a realtor, what can you do? Okay? And that's where you draw upon your skills and your talent. That's when you draw upon, for example, Larry's suggestion, talking to other parties. Okay? That's when you use the things that you do best. Not the things that I do best, but the things that you do best. You can't really prevent anybody in a short sale and any other transaction from breaching. You could try to convince them not to.
I guess to protect the earnest money, maybe not having the earnest money deposited into escrow and having that written up as part of either the counter or later on, I would suggest in the addendum later on after the approval.
Okay, so here's the question. What about protecting the buyer's earnest money deposit? Well, if you use the car short sale addendum, the default language states the deposit will not be made until after lender approval.
But he already had that.
Okay, you already had that. Okay. Now, your experience out here in the Antelope Valley may be different than mine. But my experience is if you write an offer saying, we're not going to make a deposit at all, your offer is never going to be accepted.
Right.
So it's going to have to be deposited sometime, either upon acceptance or upon lender approval. So you tell me what your third option is as to when you're going to make that deposit, when you know the seller's not going to breach?
I guess what I'm saying is that after the lender approval, an addendum would go out from the buyer's agent to the listing agent stating that the deposit will be, the earnest money will be deposited not now, or just strategically delaying that process until 10 days or so prior to the closing of escrow.
Okay, so if I'm understanding your comment right.
Do that in writing. I don't know. I guess that's my question. Is there something that maybe at that point they're already vested in you? That would be a negotiation leverage point at that time.
Well, let me see if I can restate. Okay, your suggestion. You have a contract. You use the short sale addendum.
Right.
The seller agrees to that contract, which includes the short sale addendum. And the lender has said, we approve this short sale subject to all of your underlying terms. One of those terms is you're going to make the deposit upon the lender's approval. Now you say, now the lender approves. The buyer and seller get together and do an addendum that says, we're really not going to make the deposit until the day before close. Okay? Well, guess what? The seller is now in breach of contract with the lender. So it says, these are the terms that I agreed on and you approved. And I have now changed these terms without your consent. Now, if you can get the lender to agree that the buyer does not need to make the deposit, until some point closer to closing, and the lender will do that agreement in writing. That's great.
Or maybe not in writing, just delaying it until you.
Oh, there we go. Now this is the woman who I was just in her office talking about a scenario, and she was shaking because an agent was considering a transaction that wasn't in writing.
I was shaking.
Okay.
I'm still shaking.
But no, it's just a deposit. We don't have to document that change in writing. And in our private, in-office discussion, she said, regarding that other issue, she said, isn't that lender fraud? And for that issue, I said, no, that's not really lender fraud. But when the lender has specifically consented to an agreement, and you are changing that without their consent, that is lender fraud. Okay? Not just for the buyer and the seller, but guess what? If you happen to be the one suggesting this as an alternative, then it's lender fraud for you too.
Well, I don't, maybe not putting in writing, I understand. However, like I'll tell you right now, I'm in a short sale situation where I'm the buyer's agent, and the short sale is due to close next Wednesday on the 1st. The deposit was just deposited in to escrow. The earnest money is my buyer's deposit. By me, I told them that I would suggest them not giving them the deposit until just this past Monday. So I waited strategically. Now the other side kept asking me, when is your buyer going to? Oh, they will. So don't worry. Yes, they will. They will. I bought the time, and then when I felt it was in my buyer's interest to have them to put the deposit in, that's what I told them to do.
Okay, so the assignment that we got was very simple. I'm hearing one word.
That happens in real life.
Of course. All right, you're letting me address the question. Oh. So I've heard some rumbling in the crowd. I've heard some nice alternative words, like stalling. And,
Kalin.
it's like, well, listen, I'm representing the buyer. What difference does it make if I stall? Once it happens, forget about the fact that we're a short sale. What is the seller's remedy? Give the buyer a notice to buy the reform. Okay?
Yeah.
All right.
Well, that's on this.
So here is where you weigh, you balance out,
Right.
okay? We've got these legal issues involved,
Right.
okay? And where you are the one who's suggesting a strategy, which is, in my view, lender fraud, okay? You call it stall, you can call it whatever you want,
This is
okay?
lender fraud.
Okay.
Wow.
The lender agreed based on a certain scenario. And you're saying, we don't really care what the lender agreed to, we're going to do something else, okay? You can call it whatever you want, okay? So, again, my role is often different from your role. My role is to give you legal advice. Your role is to say, okay, now that I know what the law says, can I balance that with what I can get away with? Okay? And you know what? Everything is kind of a balance. Okay? You've got corporations that make decisions all the time. They go to their lawyers, and lawyers say, you can do X, Y, or Z, and they say, yeah, but it's not as profitable to do it that way. I want to do it A, B, or C way. The lawyer says, you can do whatever you want. Okay? Because that's a business decision as to how you're going to proceed. Okay? But when somebody comes after you for doing it A, B, and C instead of X, Y, and Z, I'm going to be there to tell you I told you. Okay?
Yeah.
Okay? And you're going to pay me very well for me to tell you that I told you so. But listen, here's the balance. You may say to yourself, I'm very pragmatic. And you say to yourself, that's only going to happen once in 1,000 times. And you know what? For the 999 times that it works, I'm willing to live with the risk of once in 1,000 times. Now I'd say, if you want to take that balance, That's up to you and your manager. That's not up to me. Okay? I give you advice of what the legal thing to do is. You decide what you're going to do with that advice.
On short sales, we do have the semi-regular occurrence of a seller just throwing their hands up saying, I'm out of here, I'm not doing it. And now the buyer is trying to cancel the escrow and get the deposit back, and the seller says, I'm off to Arkansas, wherever I'm going, I'm not signing anything, you can't reach me, and so there's no way of getting something back from them. Can you build into the contract on an addendum? If buyer were to cancel escrow for contractual reasons and present cancellation of escrow to seller, and seller does not respond within 72 hours, escrow is automatically canceled and earnest money goes back to buyer. Can that be done?
Can you build in an automatic cancellation into the contract that includes not just the cancellation of the contract, but a return of the deposit?
Right.
And I have to say that is inconsistent with the CAR purchase agreement.
So how do you protect your buyer against that scenario?
How do you protect your buyer? Well, in what you may be able to get away with, quite honestly, in your area of practice, that I suggest they can't get away with in Manhattan Beach or Beverly Hills or Silicon Valley, you may be able to get away with the deposit that's under the small claims list. Okay? Because I kind of hear the same thing you do. That the biggest problem is how do we get these deposits back? And if you are fortunate enough to be in an area where you can keep your deposit low, under $10,000, while it may not be as good or sound as simple as having an automatic return in escrow instructions, those things are generally not going to be enforceable. Most escrows, maybe you'll do an in-house escrow and they don't really care, but most independent escrows won't do that. Okay? Again, maybe if you have your own escrow and they want to do it, that's their business and that's their risk decision. Most independent escrows will not do that. Okay? But at least if you have a small enough deposit, your buyer can go to small claims court. It's really not too hard to get a judge to order that deposit be released.
Sure.
You take that to escrow and they'll release it. They're not going to require mutual instructions if you have a court order. Okay. I have a whole bunch of other questions. Do you want me to get those or just keep taking them from the
Let's
audience?
go ahead and do number 2 because number 2 is very important. Skip number 3, but let's do 2
Okay.
because I think that's going to affect everybody.
All right. Great. Number 2.
Is there a form?
Great. Is there a forum to warn short sale sellers about taking fixtures? And that leads into question 6.
Right.
You guys don't have these questions, I don't think. I just have. Which is, what is the definition of fixtures and how to address when they're taken? What do you do when they're taken? So, thank you for giving these to me in advance. So last night, I said, you know what, I'm going to go up and find a definition of fixtures. Okay? And there's this real estate resource book called Miller and Starr. And it's basically the Bible of real estate law in California.
What is it?
It's called Miller and Starr.
Star?
Starr. It's like a 20-volume legal resource. Okay? So let's see what it says about fixtures. A fixture is a thing deemed to be affixed to the land when it is attached to it by its roots, as in the case of trees, vines, or shrubs, or embedded in it, as in the case of walls, or permanently resting on it, as in the case of buildings, or permanently attached to what is permanent, as by means of cement, plaster, nails, bolts, screws, etc. Okay? Does that help you out? Let's go further. Because if you thought that was abundantly clear, I want to make sure you do not leave here with that impression. Okay? The method of annexation is only one factor relied upon by the court in determining whether something is a fixture. Okay? A court needs to consider Okay, we talked about number one, the manner in which it's annexed to the property. The item's adaptability to the use and purpose for which the real estate is used. The intention of the party who put it in the first place. The difficulty of removing the item. The destruction caused by the item's removal. And the relationship between the parties. Wait, I'm not through. Here are the two major points to realize when we're dealing with fixtures. Okay? And it's true in a short sale, and it's true in any other sale, a regular sale. The issue of whether something is a fixture is a question of fact, meaning it's up to the judge or the jury to decide. Okay? And you're going to love this second item. The exact same item may or may not be a fixture depending on the circumstances. Okay? There you go. So what do you know about fixtures now? Less than what you knew before? But what I think we can come away with is, there's a few things the court's going to look at. How is it attached to the property? How is the item attached to the property? I'll give you an example. I just made an offer yesterday on a house that I want to buy for me to live in. And my real estate agent just happened to have the MLS printout there. And I was looking at the MLS printout, and it said a few things were not included. Okay? It said, of course, the refrigerator and stove. Right? And I had already written my offer. Right? And I had my agent check the box in paragraph 8 of the purchase agreement. I said, I want to make sure that the refrigerator and stove, it was a Viking stove and a Sub-Zero refrigerator freezer. Okay? So it's like, I didn't want to take any chances. I didn't even know about this MLS printout. Right? It's like, these people are planning on taking those things with them? And it also said, okay, the outdoor grill and bar. Now, I have an outdoor grill. You might roll it back and forth. There was a separate grill, probably 10 feet long, 3.5 to 4 feet wide, a sink in there, okay, a garbage in there, and then there was a separate bar about the same length, cemented into the ground. And these things are there. But in the MLS, I said, it just had to see it sitting on the desk. It said, the seller's financing. What's he going to do? Come in with a jackhammer? Okay? Now, I can't imagine any judge saying that outdoor bar and grill was not a fixture. I just can't imagine that. You know, if I didn't address it, you know, in one way or the other, the contract said, there's no frickin' way somebody's going to say that wasn't a fixture. Okay? There's this whole nice cemented area around the pool, and now there's going to be 2 10 by 3 foot holes in the ground. Or I guess that maybe we'll just rip out the cabinets that are surrounding, you know, the Sub-Zero refrigerator free. I don't know. Okay? So some things are going to be pretty obvious. All right. So that's the first thing I want to, how is it attached? The intention of the parties, usually not a problem, but again, like in our contract, we address refrigerators so specifically because it's caused so many problems for our members. What about something in between? We got something we also addressed in our last revision was, you know, what about widescreen TV, flat screen TVs that are mounted on the wall? And based on the language we put into our contract in 2010, the answer is now basically this. The TV goes, but the bracket stays. Okay. If you have a bracket and you mount the TV to a bracket, the TV is not attached to the physical structure. What's attached to the physical structure? The bracket. The bracket is the one, you know, depending how big your TV is. Now, I got a little TV out of the bracket. I don't have a very good bracket. I could probably unscrew a few screws, maybe patch them up. I might be okay with that when I sell my house. Okay? But somebody's got a big 72-incher on one of those big brackets, and the brackets are screwed, you know, directly in, you know, with those major bolts. That's going to be considered a fixture almost every time. Okay? So there's no precise definition. What I tell you, you can have the same thing be different in different situations. So I think you could use really some common sense when you think about it. Okay? You can't point to anybody as a particular definition because there isn't one. There isn't one. But you look for a few main clues. Okay? Can you easily remove it? Are you going to cause damage? And what is the degree of attachment? And if you just think about those basic things, you're going to be right 95% of the time. Okay? There was a woman who had a question earlier.
Well, it's just when you started off with the definitions about things being embedded in the soil, which technically makes trees and bushes also fixtures, which is like ridiculous. But if you're going to take that to the extreme, every single coffin in a cemetery is then a fixture because it's embedded in the soil of the property of the churches.
And I'm going to ask Larry, do you have a cemetery broker's license? Then I don't care.
Let's stay on topic. One thing I do want to mention is one of the reasons, the main reason why this comes up is in short sales. House looks great, put an offering, you're going through escrow, you do your final walkthrough, and then a day or two before the close of escrow, the guy backs up with the truck and takes out lighting fixtures and things.
Okay. So here's what you do. And especially in short sales, here's what you do. Okay? First of all, you try to be as clear as you can with your contract. Okay? During your final verification, bring a camera. Bring a video camera. Everything was here. Okay? Some people will tell you, don't go to the property between those last 5 days and the day of closing. Don't find out if the seller is taking it before closing. Some people will tell you this for this reason. Okay? Because if everything was removed by the seller after close of escrow, that's vandalism and it's probably covered by your insurance policy. If everything was removed prior to close of escrow, that's not vandalism. Hey, it's not your property prior to close of escrow. Okay? So, but at least if you have your pictures or your videos, you're going to have one or two areas of potential recourse. Okay? If it happens to have occurred after close of escrow, you have a potential claim against your homeowner insurance. Okay? And again, whether it is enough money to justify making a claim is another issue. Okay? If it occurs before close of escrow, you know, where the insurance company doesn't believe you that it occurred after close of escrow, you deny your claim. Okay? Regardless of when it occurs, you have a claim against the seller for breach of contract. Now that brings us back to the problem we discussed earlier, which is how do you get money from the seller? Okay? But at least this way you've got some evidence, and if you need to, file a small transaction against the seller, hold on to your judgment, wait for the economy to turn around, and then surprise the seller one day when they go to take money out of their bank, and you already took it out.
The reality is a lot of buyers will say, I just lost $10,000, I'm canceling the escrow, I'm not completing the sale, so that can happen. What we're wondering is there a card form, or Neil, can you make a card form between now and tomorrow that, that we can use to warn sellers of the potential, what would happen to them if they take these fixtures? Okay. Between now and tomorrow, no. Can I bring this suggestion back to our Sand Forms Committee? Yes. Okay. Okay, so that's when you protect yourself, have a clear contract,
That doesn't mean it's going to help you with somebody who does not have a clear conscience. So at least you've got something that you could use and take some kind of photographs, at the beginning of the transaction and at the end of the transaction. And you mentioned something, you said, somebody said, well, there's $10,000 worth of stuff that was taken out, I want to cancel that stuff. That raises, unfortunately, an ambiguous area, which is, at what point in time can the buyer cancel because of something the seller did that's in breach? Okay? So when the seller takes the stuff out, the seller didn't breach the contract. The issue is it a significant enough breach that would justify the buyer in canceling? Okay? And again, is it significant? Is it material? There's no bright line test for that. Okay? But let's use your example. It's $10,000 worth of stuff that was taken out, or it's going to cost me $10,000 to repair what was taken out. Okay. Well, if I'm buying, a small home out here in the Antelope Valley for $70,000 or $80,000, that's more than 10% of the purchase price. Okay? And while there's no bright line as to what's material, I don't know, I'm just thinking independently, that's a pretty significant part of what I'm paying for this property. If I'm buying a property for $2.5 million and somebody takes out the toilet, all I've got is a breach of contract claim. It's not a significant enough breach for me as a buyer to justify me canceling the contract. So that's kind of open-ended. I know we don't always like to hear about those things, but sometimes we just kind of have to see, how does it look in relation to the transaction as a whole? Okay. All right, so you wanted me to skip the next one. Let's see. Next, but the fourth question on my list.
Yes. And by the way, you guys don't have a list. What you have will be covered between 12 and 1:30.
Right. And question number 4 is, can the parties, or through their agents, which usually happens, build into a contract passive contingency removal?
By the way, Neil, can you just briefly cover what normal contingency removal is?
Right. In the CAR contract for the last, almost probably 10 years now. Yeah, it is 10 years. We provide for something called active contingency removal. I actually like to call it written contingency removal. The contingencies that are in place at the beginning stay in place until they have been removed in writing. Okay. Passive contingency removal says once a certain time period has passed, the contingencies automatically go away. Okay. Basically, one requires a written removal of contingency. The other has the contingencies removed automatically. Okay. The CR contract for the last 10 years has been the former. Requires written contingency removal. And you have some sellers who are thinking, I don't like written contingency removal. I want to know when the 17 days are up, this buyer's contingencies are over. And the issue is, can the contract be modified so that you change, it's not a default, it's the only language in our contract for active, and change it to passive or automatic contingency removal. So that gives me 2 things to think about. First of all, is it even legal to do that? And the answer is absolutely yes. Before the year 2000, the car contract had both methods of removing contingency in it. Had both active and passive, and you had to choose. And actually before that, before 97, it was only passive or only automatic removal of contingency. And then for a 3-year period, there was both. And now we only have active. So the question is, was it legal then? Yeah, it was legal then. Is it legal now? Sure, it's legal now. Okay? But it's difficult to do. Okay, I've seen contracts, and I've seen people submit language to us at CR on the legal hotline where they say, passive contingency removal. And I think that just does it. But the entire CAR contract is built around everything needs to be in writing. That if something doesn't happen, you issue a notice to buyer to perform. So it's not as easy to change that by just saying active contingency removal, or inspection contingency will automatically be removed after 7 days. It's not easy to do because you really have to go in and see how they're going to affect everything else that this contract is built around. So while it's legal to do so, it's not easy to do so. And the seller who wants to do so should really have a lawyer draft language. Okay? And then, is it invalid? No, nothing invalid about it. Okay? What you need to think about, even when you're representing a seller, what you need to think about is that a good policy? Okay? And when I'm asking you to think about that, I go back to why did Carr change the way it approached contingency removal so many years ago? And the reason we changed it is because with passive or automatic contingency removal, buyers get surprised. I did not realize my contingency is removed. Now, even if I have a valid reason to get out of the contract, I will lose my deposit. Who is supposed to keep track of the timing for contingency removal? And if I would say, you! The reason I lost my deposit was because of you. Okay? So, it's legal to change it. I don't think you should be writing the language to change it. Or is it something that you want to encourage? And I would suggest it's something you do not want to encourage because our members have avoided going to court time and time again because of the change in the approach. All right.
By the way, right at 12, we'll have a little, I'll go up, talk a little bit, and we'll...
All right. Do you want me to address the others? You got like a barcode?
Barcode would be a good one to show.
Okay. The last question on my list, and again, I'm glad you sent it to me in advance. Okay. Can Carr put a barcode or QR code on docs for electronic filing? And the answer is, we can, but is it going to be useful? Okay. So I don't know about this stuff.
Who would we ask?
You would ask Josh Sharpman, who sent this email 2 days ago. So let me go through some of, well, first I'll give you Josh's conclusion. It's not a good idea for CAR to do. Okay? Some of the stuff that he says in here, I have no idea what he's talking about. Okay? Like, the superior solution will be to use web services to implement the function rather than barcode. So maybe some of you know what that means. I have absolutely no idea what that means. But here's some things that I do know what it means. First, you need to have space on the form for a barcode. Okay? So the question is having a barcode so important that the form gets longer, you cut something out of it that's already there? Okay? Then you go down and say, let's assume you want to process the barcode automatically, perhaps by receiving a fax. Given the registration issues with faxes, you need to repeat the barcode 2 or 3 times in order to have more than one try to match. So it's not just having it there once, it's having it there twice or 3 times. Okay. Next he says, so now let's say we do that. You've got a barcode. You got it there not just once, but twice or 3 times. Okay. What will it do for you? It will identify the form and the page of the form. And if CAR is going to put the barcode on CAR standard forms, that means all you're going to have identified is a blank page, or a page in a blank form.
That's what we want.
That's what you want. Okay. And how will that help you? His question is, how will that help
We
you?
use a paperless system that right now you have to put a cover sheet for each individual form
Yeah.
to put it into this web-based program.
All right.
With barcodes, we could eliminate those and just set it up to where it knows the page and puts it right into transaction point, saving a lot of time and effort. Sorted automatically. So that would speed us up.
But a blank.
Well, it'll just tell us what the form is and what the page is.
Right.
So,
And what about the information that's on there? You don't want that?
It'll be in there. We scan it in there. All the barcode does is put it in its home.
Okay. I'll tell you that Josh doesn't think it will do what you think it will do.
Okay.
Okay?
So
So, I will tell you,
Can I email Josh?
Josh Sharpman, JOSHS, Josh S. at car.org. Okay? He thinks it is not an elegant solution to even the issue that you raised, and maybe he could discuss with you why.
No, that would be perfect.
Okay.
Time for maybe
12
one
o'clock.
more quick question, because we have a couple minutes.
All right, so we got 1 minute, so,
And that clock is maybe a tad bit back.
okay.
Audrey, I know that you had a question that I didn't get a chance to get on the email, so do you want to ask it real quick?
Yeah, I have a buyer in a short sale situation.
Time's up.
Yeah.
Let me make one quick comment while Audrey's doing that. We do have people coming for 12 o'clock right now. I assume is everybody here is staying for 12 to 1:30, yes? Okay. If anybody needs to leave, stand up now, go to the side and listen to the rest and then leave. But right now we need to get these seats available, so everybody needs to move into the center. No seats between any agents, just have them available at the end. So everybody please move in, get a team on that and do that for me, and let you leave room for our guests that are coming in. Real quick, just 1, 2, 3, go. We can do this in about 10 seconds and we'll be done. Thank you, Randy. Come on, Randy. Come on, Larry. Close the gap, gang. I know everybody wants that each MC. You're not getting it today. Okay? Come on. Everybody make that move? On the form, are we able to go through that in about 45 minutes? I definitely want to go through it, because you see there's other questions we would love to get.
Yeah, I've got a huge agenda. I don't need to go through it.
And Audrey?
We'll talk about it later.
Audrey,
No, we can talk about it.
We're going to talk about it right now just as we get going, but let me do this. Let me just cover a few agenda items. Go ahead and have a seat, and then I'm going to have you ask a question as we get the second part of the meeting going. The folks that are coming in right now, we have the whole front row available. So come on up. Come on up. Find your seat. Come on in. No seats in the middle. Christina, Kalin, why don't you see a gap right there? Come on, Bill. Let's see team players. Everybody moving in. No seats in the middle. Wendy and AC, why do I keep space there? Okay, good enough. Okay, Christine, you're making sure there's no empty seats there. Beautiful. Let's make it happen. Thank you, ladies. Sweet. Now we can fit more people in. We've got seating outside. I know how this second part goes. We'll have about 40 people show up at 12:05, and we'll look at them and say, you should have been here on time, right? So, but that's okay. It's going to be great. A few things to cover real quick. Number one, cell phones need to be off or silent. Another cell phone goes off, and Angelique has a gun in her purse. So that's step one. Second, we will write a check for $25 to KW Care out of your checking account, okay? Yeah, maybe so. We can afford it, no problem. Second, next Tuesday, 5 to 6:30 in this room, career night. I will be teaching people how to get their real estate licenses, or people that are interested in Keller Williams want to come and check us out. They're welcome to come. A non-formal setting, 5 to 6:30, Tuesday the 31st. Invite friends, neighbors, family, other agents, that's fine. Next, family reunion. Those of you that are going or are thinking about going this year or next year, I will be conducting a meeting at noon, 1 week from today, next Thursday. In place of Taco Thursday, it will be a family reunion, orientation/preparation, and as all of us know, family reunion means our national convention. It's in Orlando this year in February, just a few weeks away. If you're going, you need to be here. Very, very important information for you to know. If you're not going, but you want to learn about family reunions, y'all come and listen, and if you don't go this year, you can go next year or just find out about it, okay? Third, productivity board is up. It's in the hallway by April's office. Use it. It's simple. Who saw the video that went out yesterday about it? Wasn't that cool? Great job, Angelique and Christina. Them, rising stars. Awesome. But easy to use. If you haven't seen that, go and look at the email. It's all written out how to use it. And if you've got speakers, click the video and watch it. It's a blast. They did a great job on it. But then use the board. We've only got a couple of videos left to this month, and I'd love to see all of our productions built up on that board. So today, put your listing, put your escrows, put your closed transactions for January on the board. Let's fill that thing up. And I want to see who all is doing business. And it's up to you to put your own name and your own numbers on there, okay? The instructions are in the email. At the end of the month, we will take a picture/video, send it out to everybody so you can see what's going on. We're still hearing Neil on his microphone. Hopefully he's not going to the bathroom. So watch the video, pictures, and then listen. I've heard people do that all the time. I guarantee you, I would never do that because I've seen it out. But anyway, listen, don't get upset if you write your numbers on the 31st of January, and then we have to erase the board on the 1st of February, but we need to start getting February numbers on in February, okay? So just be prepared for that. So get your numbers on today so we can see them for today. That'll be great. And last but not least, we also have an award ceremony for Kalin and Antelope Valley. It is our annual award ceremony. It is coming up on February 2nd, Thursday, next week, a week from today. It's going to be great. It's going to be at Crave Bar and Grill. It's on Palmdale Boulevard. Watch for the email. It's going to be from 5 to 7 p.m. I want everybody to come. The office is going to buy appetizers for everybody. Those are going to be free. You want to buy a meal, you're on your own. You want to buy drinks, you're on your own. But appetizers will be there. There's going to be great camaraderie. We're going to give out the awards. Come and see what happens on that night. Watch for the email on that, okay? February 2nd, Thursday, from 5 to 7, award ceremony. And that's the annual awards for 2011. We're going to get them all out that evening, and it's going to be wonderful. Nice class and a whole enchilada. Last thing I want to announce is we have, in my opinion, but you can't get the big head now, I know, the premier speaker for legal information having to do with CAR, California Association of Realtors, with us today. His name is Neil Kalin. He's the Assistant General Counsel for CAR Legal, and I want you to help me welcome him to the front of the room.
Oh.
Neil Kalin! Wow. Two introductions in one day.
Thank you again, Larry.
You're welcome.
Wow, it's great to be here. It's like I never left. So hopefully you all have in front of you a package of materials.
Can we start off with Audrey's question and then go to that?
And we can do exactly that.
Audrey, go right ahead.
Okay, so I have a short sale buyer with a signed contract between the buyer and the seller. The offer has been submitted to the credit union for about 60 days now. We just recently found out they have mortgage insurance. And now the mortgage insurance company, the credit union's all good with the sale. Mortgage insurance company is turning down the sale. They won't give the borrower, the seller, or the listing agent any kind of explanation as to why. And I keep hearing different things about mortgage insurance. Do you have any?
Okay, so what's your question? Your question is, you're representing a buyer. Buyer's made an offer on short sale property. I'm going to assume from your question that the seller accepted the buyer's offer and submitted to the lender, which in this case happens to be a credit union.
Correct.
Credit union is okay in approving. Credit union wants to approve the short sale contract between the buyer and the seller, but what do you know? There's mortgage insurance. And the mortgage insurance company says, no, we don't approve, and we're not going to give a reason why. So the first question is, do they have to give a reason why? And the answer is no. The second question is, what can you do about it? Well,
What can we do about it?
it's probably nothing, okay? But if you know anybody who knows anybody who knows anybody who has any contact anywhere, okay, in the insurance company's business, maybe you get to somebody who can help speed this along. But what have you encountered? I don't know if you've encountered this a lot. We hear this all the time. If the banks are hard to work with, the mortgage insurance companies are impossible to work with.
And I've
Okay?
heard different things. I've heard they require 80% of what's owed. I've heard they're just going to turn it down completely. They might as well not even.
Right, we've heard lots of different things about what they require. Is it 80%? Is there no particular percentage? Are there certain factors or considerations that are taken into account? And the answer is every one is different.
And since I represent the buyer, do I have any resource trying to call that?
Do you know of any resource for her to call to find out about this?
I have absolutely no
Does
resources.
anybody in this room know anything about this? Okay, we'll have to find out later.
Okay.
And then maybe within this room.
We have another question, but I don't think now is the time. We're going to take some after I do some of these prepared remarks.
Okay.
Oh, Tom, okay, go ahead.
Ask the credit union how much they're gonna get to go to foreclosure.
What was that? I didn't hear you.
Ask the mortgage insurance company what they're gonna get if it goes to foreclosure, and that's the obvious question. Okay, real quick question, does everybody have a handout right now, because we have answers if you don't? Okay, so will you please, Ron, will you do me a favor and make sure that everybody gets it, just pass it down, Ron? And who needs a pen? Who does not have a pen, because I'm gonna throw it at you. Who else needs a pen? You ready? Look at that, I can see you right between the eyes. Hey, Anna, you gonna catch it from there? Ken, coming to you, Ken. Okay, anybody else, we're good? Good. Neil, go with it, buddy.
Over there? Pen?
No.
Oh.
Okay, let's go ahead and cover the material that we'll have. We'll probably have about 30 minutes at the end for Q&A.
All right, great. I think I don't have your material, so I'm going to take one right here. Because apparently some of you heard that I am like Gallagher and you were afraid to sit in the front row. So there's an extra one right here. Okay, you have the same thing on it, that's all I want. The first one is legal update. First page. All these new laws that affect you for this year. Okay? And I just included some of them. All right? Second page, I talk about several things. New forms in November release, the new forms and the revised forms in November. I talk about what's coming up for April of this year. And there's a whole list, I don't know, what, about 7 cases that I thought were interesting. I'm not going to get to everything. Okay? So I'm going to try and hit it up, and if you have a question about something I don't get to, feel free to ask it. You know, if we got time, we'll address it. So let's start with page 1. New laws. Right there, A, short sale and deficiency. And notice this law took effect July of last year. But I just want to make sure everybody's aware of it. And what does it say? It says that a lender who approves a short sale on residential 1 to 4 property is not permitted to seek a deficiency against the borrower. Okay. Now, in January of last year, this particular law was only effective for lenders who held a first trustee on residential 1 to 4 properties. The law was amended in July to apply to all lenders, again, all lenders who approve a short sale. It doesn't say they have to approve a short sale, but if they do, they cannot go after the borrower for the difference. It's essentially treating short sales like non-judicial foreclosures. Okay? But only for residential 1 to 4 properties. Look here, there are a few exceptions. Okay? If the borrower commits fraud, the lender is not bound by this appointment. Okay? When does it say when that fraud is? No, it doesn't say when that fraud is. So we don't know if that means fraud at the inception when the loan was first taken out, or if it's fraud in the short sale approval process. That's not really clear in the statute. Okay? What are some other exceptions? Are there certain borrowers who are not protected? Yes. If the borrower is a corporation, an LLC, or an LLP, which is a partnership. That type of borrower is not protected, right? Because I think the legislature said, well, if you're a corporation and you set up an LLC or an LLP, okay, you're not the typical homeowner that needs this type of protection, okay? You're probably in a business, okay, maybe the rental business, so you don't get that protection. But also notice something. The property does not have to be owner-occupied, as long as it's residential 1 to 4 property, even if it's not owner-occupied. Okay. You've got an individual owner, and the short sale's approved, that individual owner gets the protection. The lender cannot go after that borrower for the business. Yes, any loan that is secured by a trustee on the property. All right, what's next? This one's just kind of quick. Oh,
Is
sorry.
there an expiration on it?
No,
Okay. Permanent.
that is a permanent law, correct. Well, that's a good question because we have a lot of laws regarding properties in foreclosure that actually expire at the end of this year. Okay? But that's not the case for the short sale deficiency law. Okay? Let me try and get through some of this stuff because I know if I take questions with everyone, we'll get to about item number 3, okay? Or C, whatever it is. Okay, notice of sale, this one's just kind of quick. Lenders or agents have to have some kind of notice that can be easily accessible, either answering machine or a website that discusses postponement. They also have to give information, by the way, in the notice of sale to the borrower about how to obtain a postponement. Okay, so the notice of sale form itself is going to be a little bit modified effective this year. Small claims, for those who were here in the earlier session, we talked a little bit about this. The small claims jurisdiction in California has been up from $7,500 to $10,000. I do want to remind everybody of a couple of things. I've got some of them in here. If the claim happens to be a bodily injury claim, you were hurt, a personal injury claim, the cap is still $7,500. I guess the PI lawyer said, well, wait a minute, we don't want to lose business. Once you start getting up to $10,000 claims, that's our territory. Don't take that away from us. Okay, so that's one. Second big exception, okay, corporations or entity plaintiffs. Your limit is still $5,000. There's actually a third exception here. Okay? If you're somebody or you have a client who goes to small claims a lot, okay, you're going to be limited in the number of times you can take advantage of it. Okay? And I believe it's if you can make 2 claims over $2,500. But for the third one, you're back down to $2,500. So, yeah, an individual claimant, like small claims court, what is the legislature essentially saying? This is not for professional plaintiffs. This is not for people who go to small claims court all the time. Okay? Okay, so you got 1 or 2 claims a year. Great, that's for you. You can take advantage of the $10,000 limit. But afterwards, you actually cut way down to $2,500. Water conserving devices. Water conservation devices. Right, so we have some laws that are coming into effect way down the line, 2014 and 2017. It's going to require all properties to have certain water conservation devices. But actually, right now, we have a box that has been added to the transfer disclosure statement to check, does the property have water conservation devices? You don't have to have them under state law. You may have to have them under certain local law, and I don't know your local issues here. But state law will not require the property to have water conservation devices until 2017. But it's basically, if there's any significant work being done in the property, starting in 2014, that's when the water conservation devices are going to need to be put in. It is not a point of sale requirement. Okay? And we're going to talk a little bit about that when we get to carbon monoxide detectors a little bit later, which is also not a point of sale requirement under the law. Okay? The law is going to apply to everybody who has a home. And so for all I know, the jurisdictions out here, okay, could appoint the water conservation police. And they may start, 2017, knocking on doors. You have a low flow toilet. You have a low flow shower. Oh, you have to. Okay. Yeah. We still need more money. So even though the law hasn't come into effect for a few years, we've already had a place to indicate compliance on the TDS right now. We just came out with a new legal Q&A on water conservation devices. And the attorney who drafted it asked me a question. He said, Neil, can I put a brick in my toilet to satisfy the water conservation device requirement? And the answer is?
Yes.
No. Because the device itself is not a water conservation device. So. It works, and as long as the water conservation police don't come knocking on your door, you're okay. It's a nice money-saving device. Okay. What else do we have? No discrimination based on gender or genetics. So California has this law called the Unruh Civil Rights Act. And under the California Unruh Civil Rights Act, a business cannot discriminate against certain classes of people. And what classes are named? Well, you could probably think of the most obvious ones. Like race, class, religion, national origin, sex, sexual orientation, marital status, okay, familial status, or the children, age, disability. All those things are specifically named. Businesses you cannot discriminate against them because they are in one of those classes. Okay? 2 classes have been added to that list. Can't discriminate against them because of their gender. It's not just their gender. It's their gender preference. Okay? So you may say, well, I don't care if you're a man or if you're a woman. But if you're a man, I want you to look like a man. If you're a woman, I want you to look like a woman. Okay? But if I'm a man and say, my preference is to be more like a woman, you cannot use that as a basis to discriminate against me. Okay? Now, we had a good question at the CR meetings last week. We had what was called a property management forum. Got 2 seats right up front. And the issue came this way. Well, might this come up in the case of landlord-tenant relationships? Well, sure, it could come up in that area. But usually when people think of landlord-tenant relationships, they think of the time of inception of the lease. Okay? But if you have somebody who, after they moved in, somehow they changed their preference, right? You cannot use that change to somehow discriminate against that person. Okay? For the genetic one, I have to tell you, I don't quite understand it. Okay? Because I don't know how somebody's going to know what their genetics are. But those two have been added. Other item, what's good to know about the Unruh Civil Rights Act? In addition to those, 4, 8, 10, 12, 13 categories, the Unruh Civil Rights Act also prohibits any arbitrary discrimination. And I've got a case a little bit later, I'll talk about that first. Okay. So if you go to something and go, okay, I've gone down the list, all 13 categories, they're not in any of them, you still may not be able to discriminate against them. All right, what's my next item here? F, no credit reports, not really for employees, it's really on employees. An employer cannot pull a credit report on a prospective employee to decide, do I want to hire this person? Okay. That's good, and that's bad, okay. January 1st. Okay. Now, you in here probably all consider yourselves to be independent contractors. Would that be a fair assumption? Yeah, is that a good assumption for this office? Anything? Okay. In real estate, you're independent contractors for some purposes, and you're employees for other purposes. Okay. For this law, I don't know what you're considered. Okay? So I'm just mentioning it. But even so, even if this law applies to, even if the court says this law applies to real estate licensees, because for this law they're going to be considered employees, let's look at some of the exceptions. Okay? If I could find where I was. There we go. Okay. Well, if you're a manager, law doesn't apply. If you have access to confidential material, you ever get confidential material from your client? Law doesn't apply. You have access to $10,000 in cash. Well, probably not all of you in your business, but maybe you got some buyers who come in with a suitcase full of cash. Okay? Okay, but look at the last one. An employee who has the authority to enter into contracts with the employer. Has anybody here ever taken a listing? That's a contract that binds the brokerage company. So even if for this purposes you are considered employees, okay, Keller Williams can pull a credit report on you in deciding whether to hire you. I don't know what the policy is here, by the way. I'm just saying that. Okay, let's go next. Well, this one's probably only going to be applicable to a few of you in this office, so we'll make it really quick. Branch managers have to have their appointment in writing, and the DRE needs to be notified. But that's not going to be an issue for most of you unless you're considering being a branch manager here, or you're considering leaving here and becoming a branch manager somewhere, which I hope you're not doing, considering this. DRE citations and fines. This one is a nice one. You could violate the real estate law and not have it show up on your record. Right? If it's something that the DRE considers to be basically minimal, and you're willing to pay a fine to the DRE to avoid your record being marked as having discipline on it. I'm sure for major cases of fraud, they're not going to say, yeah, give us $2,500, we'll make this all away. But I'm sure for minor infractions, it's basically going to be treated kind of like a, parking ticket, more or less. Okay. What happens with that money? It goes to the DRE recovery account, which is a pool of money that is used for principals who have sued a real estate broker for fraud and have received a judgment for fraud against the real estate broker, but are unable to collect. there's what's called the real estate recovery account. And a plaintiff who has sued a broker for fraud, got the judges for fraud, broker is unable to pay, that principal can then apply to the GRE to try and get some money from the recovery account. Okay? So it's actually good for you. You can avoid every little thing showing up. So when somebody goes into the GRE database, not everything's going to show up anymore. And it winds up being a good thing because it will help fund the recovery account.
Get out of probably something.
Okay. So how many times can you get out of jail free, basically? And I have to.
$2,500, nothing
That's right. And the answer is, I'm sorry, I really don't know. Okay, I apologize. But there is one thing that's important here, and I kind of heard alluding to it up front. This is discretionary on the part of the Department of Real Estate. So to think that you're going to be able to keep coming in with $2,500 and we'll keep looking the other way, since it's discretionary in the first place, not likely that they're going to be very lenient on the second or third time. No.
Are brokers able to see that it was removed, or we also are not going to be privy to that information prior to hiring an agent?
The information is not going to be available at all online. It's as if it did not happen. That's why I say, to me, it's more like a parking ticket. Okay. And so I guess the issue will be, we'll find out in the future how lenient or stringent the Department of Real Estate is. You know, eventually they'll kind of figure out through their auditors what justifies giving this citation in effect and what justifies going through the full-blown DRE disciplinary hearing. Don't know that yet. Okay. What do we have next? Probate exemption probably doesn't come up a lot. I just put it down because I thought it was interesting. Increase the exemption for real property so you can avoid probate if the thing that's being transferred is real property from $20,000 to $50,000. Now, is there anything that can sell for $50,000? A lot. Okay. Huh?
We got a few we can show you.
You guys need to show. Right. This exemption is not going to do a lot of good in most parts of the city. But for here, it might be. Right? So that's the real property exemption. I put down there the total estate exemption has been increased as well from 100 to 150. Some changes to the change in ownership statement. Okay. Good change, more time to file it. Bad change, if it's not filed, the penalty has been increased. So my guess is who needs to pay most attention to this? Probably the escrow company. Okay, property valuation influence. What can we say about this? Well, I have to tell you. What's new about this? A licensee cannot bribe, extort, or intimidate an appraiser. It's like, did you think before January 1st that you could do that? I don't get that. And what else? A licensee cannot have any direct or indirect interest in a property that's making a valuation. So you're doing a VTO, you can't have any interest in that property. Condo rental rights, not just condo, any property in a planned development, common interest development.
Oh.
Okay. So what does this rule say? That if when you bought into the development, you had the rights to rent out your property, you continue to have that right even if the HOA rules have been changed to say no rentals allowed. Okay. Right, well, there's a lot of homeowner associations say only 20% of the properties can be rented. Okay? And the issue is, what were your rights when you bought into that development? Now, something that we've heard, this law went into effect January 1st of this year. A lot of homeowner associations amended their CC&Rs at the end of last year so they could avoid this rule. Okay. CAR actually tried to get the bill passed that did the same thing, tried twice under the Schwarzenegger administration, and twice he vetoed the bill. Okay? And there was a lawsuit that we acted in the capacity as an amicus. We wrote a brief to the court saying, where there was a change, and the homeowner said that change isn't fair to me. In that case, I wrote the brief, but a long time ago, the homeowner had something like 17 units that she was renting out. And the court said, well, too bad. You're renting out subject to the HOA rules. You agree to the HOA rules. The rules were validly amended. Too bad. That's why. So 2 times in the previous year, CR tried to get this bill passed, was unsuccessful. Last year, with Governor Brown, we were successful in getting it through. Okay. Tenant smoking restriction. Sorry about the spelling error there. Now, it's something that I just presumed was okay all along, but the legislature has made it clear now. A landlord has an affirmative right to prohibit smoking in the premises. Not just in the premises, but in the common areas. The lease has to explicitly say so, and if there's only certain areas where there's a restriction, has to define those areas. What about an existing lease? An existing rental? And now you're a landlord, you have a client who's a landlord, and they want to put a restriction into the lease of the rental. Is that possible? Sure. Okay. I believe this is a non-rent control jurisdiction. Is that right? Okay. So you can change the terms of the tenancy by giving a notice. And then the notice will be in writing and it will say, for example, no smoking inside, no, smoking only allowed in the common area, or whatever it is. Okay. Now, CAR for many years had a provision in our lease. The default provision, as it is now, is no smoking. No, we allow smoking, but you can check a box to make it no smoking. Okay. We had that provision in our lease for many years, because we assumed the landlord had the right to do that. Apparently, there was enough questions about whether a landlord could do it. Did you know if you use the car lease? Okay. It says, and you check the box, it's no smoking of any substance. Next one, what do we have there? N. Termination if there's domestic violence. Well, there's already a law in place that allows a victim of domestic violence to terminate a lease. So this is when can they exercise that right? So now it's clear. Within 180 days of receiving a temporary restraining order against the perpetrator, okay, we're filing a police report. All right, what's the next one? Oh, the eviction for dog or cockfighting. Right, the Michael Vick rule. So actually, there was already in place a law in California that allowed a landlord's property to be seized for dog fighting. That's been amended to also include cockfighting. And landlord had a question, well, can I evict a tenant that does this? I'm not authorizing it, but I don't know what I could do. Okay? Well, the law has been made clear. It's a public nuisance. And that's grounds for eviction. Which is really only fair, because if the government can seize the landlord's property, but the landlord doesn't have the right to evict the tenant, well, that's a terrible situation. And finally, 2012, we got a law dealing with political signs. We're in an election year. A landlord must allow political signs, right, regardless of your political feelings or affiliations. Okay? The landlord can restrict the location and the size of the sign. What do we say here? Landlord, if their sign can be no more than 6 square feet. Okay? So, not one of those big things you see on the side of, sky rises. Okay? Has to be removed within 15 days after the election or whatever is before the legislature at the time, whatever the sign has to do with. What's kind of interesting is, with the last little sentence fragment, for multifamily residences, the tenant has the right to put the sign in the window or on the door. And that was kind of interesting because most people think if it's an apartment building, maybe the outside of the door is common area or it's the landlord's property. But what good does it do to post a sign inside that only the tenant can see? I'm from that guy, yeah. Every time they come home, every time they leave. Right? So it actually includes the outside of the door. All right. Let's turn the page. Let's look at some other stuff. So we'll talk about forms. We've got the November form releases. CR releases new and revised forms twice a year in November and in April. So what was released in November? The first one, additional broker or agent acknowledgement addendum. When would you use this form? If you have a co-brokerage, taking a listing with another broker entirely, okay, assuming that's been authorized. Or where I think this form will probably be used most of the time is when you have some kind of arrangement with another salesperson in the office and your own brokerage company. Maybe your partner. Okay? You're going to work together on the transaction. Okay? This form acknowledges that. This form does not set up your partnership agreement, how the broker is going to split the fees, what your services are going to be. But this form lets the principal know, basically, that they deliver a document to you, contingency removal, notice of reform, whatever it is, and you use this form and you also name you on it, delivery to you is the same thing as delivery to you, and vice versa. Is this a required form? No, most of our forms are not required. This is an optional form. We think it will help in transactions. You could put both of you on the listing agreement. Okay? One thing this form does is it makes it clear that the agency relationship that's tied to one is also tied to the other. And that, the one thing I said, delivery of documents to one is the same thing as delivery of documents to the other. Okay? And so really it'll be up to your office to figure out, do they think this form is going to be helpful and useful in transactions? Extension of lease. I think we finally got it this time. Why do I say that? CAR had a form, and still has a form, called Change in Terms of Tenancy. And there was a block in the middle of that form that would be used when a fixed-term lease was being extended. And our members complained. They said, well, all I'm doing is increasing the rent or having a different security deposit or changing some kind of a term. As a landlord, I don't need the tenant's consent to do that. All I have to do is give them a notice, not changing the term. But there was this box in the middle of the change in terms of tenancy that was really only needed if you were extending a fixed-term lease. People were saying, why do I need the tenant's consent to a change? And I said, you're right, you don't need the tenant's consent. Just ignore that part of the form. So it's creating so much problem, we took it out of the form. And we just put a tenant acknowledgement that they've received the change. And after we did that, we heard from members saying, where's the extension? I said, okay, well, we're certainly not going to put it back in the change of terms of tenancy until we created a new form just to extend a fixed tenancy.
And right there,
What's that?
you can change the, deposit or any other term.
You can change the deposit, you can make it no smoking, whatever it is that you're otherwise legally allowed to do.
Okay.
Okay? Can you also do that with the extension? Sure, yeah, you can change the term and extend the term. Okay. Water heater statement of compliance. Well, you probably all know there's most sellers dealing with 1 to 4 property have to complete a water heater and smoke detector statement of compliance. But certain sellers are exempt and they don't fill out the transfer disclosure statement. And in the transfer disclosure statement now, there is paragraph B, section 2B. There's the certification, there's the compliance certification. If you have certain sellers that are exempt. So they're not going to fill out the TDS. But there's no exemption for the water heater statement of compliance. So certain exempt sellers still have to fill out a water heater statement of compliance. How are we going to do that? And we had a separate form called the water heater smoke detector statement of compliance. And you could be exempt from smoke detectors, but not be exempt from water heaters. They said, okay, so in those situations, we'll give you your own form. CAR, if you go on our website, we have a list of disclosure charts, and you can see those exceptions. And finally, in section 2, item D, optional verification of electronic signatures for third parties. What's this form for? It's a form that says, yes, I really did sign the documents electronically. And we say it's for third parties, because like, who wants this form? Well, we've just heard that some escrows, some titles, some lenders, they don't believe it. They don't believe it when they get a contract with electronic signature. So they want to see something that's actually signed, hard signed, that says, we actually electronically signed everything else. Okay. So if you happen to have that situation, the lender, the title company, the escrow doesn't believe it, then you'll probably want to go and use this form. Otherwise, you're probably not going to need it. What kind of revised forms do we have? First one, denial of rental application for credit reasons. Okay. So what happens? More and more of our members are going into property management. And we've had requests for a denial form for years. Okay. Year before last, we finally created one. We released it at the beginning of the year, because we released it in April. Right after we released it in May, the federal government changed the regs. Okay, so we pulled the form down. We revised the form to comply with the regs, and that's what the new form is. Okay? And you're denying somebody credit. Okay. Now, what I want to say about this form is, some people think, well, if I'm turning somebody down, I'm not going to rent to them based on that credit. Okay? But it's really neat for any adverse action. So let's say you have some bad credit tenant applicants and you say, well, I'll rent to you, but your rent is going to be higher to make up for my rent. Or I'll rent to you, but because of your bad credit, you need to give me a bigger security deposit. Okay. Guess what? You need to use this form. Even though you're accepting them as a tenant, you're still taking an adverse action against them based on their credit. All right, what's the next one? The HOA information request. Long-time form CR had, but there was a law that came into effect January 1st of this year that said HOAs cannot bundle their fees for the required documents in an HOA transfer with the not required documents for an HOA transfer, meaning not legally required documents for an HOA transfer. That's one thing. Second thing is, for the required documents, they have to list out where the requirements found in the Civil Code. And for the not required documents, there has to be a list of the separate fees for each particular document. Okay. So the legislature came out with a brand new form for this. It was really modeled after the existing CAR HOA form. Okay, so many of you may look at it, you may not even notice any difference. Okay? But there's a place to put the fees, there's a place to put the total, there's information like that in there. Transfer disclosure status. Okay, well, we already talked about the water conservation devices. Earlier last year, we added a box, do you have carbon monoxide detectors? I mean, we didn't add it, the legislature added it, so we had to modify the TDS. It's a legislatively mandated form. Okay. And I'm going to talk more about that in just a minute. The short sale information and advisory form. We referenced that July 1st law about no deficiency judgment, whether it's a first or a junior lien that agrees to a short sale. We beefed up our language about fraud and suspicious activity in a short sale. Okay. About things to be aware of. And finally, the addenda. Now, I don't know if you've noticed it. I don't know if you've noticed this, Larry. But in November, CR changed the addendum, the basic addenda, basically a blank form, right? Whole page, just a bunch of blank lines. Okay? There's two things that we did to it. Up at the top, this is an addendum to what? Residential purchase agreement, commercial purchase agreement, lease. What did we add? Listing agreement or buyer representation agreement. And then at the bottom, we put a signature line for the broker, because if you're having an addendum to the listing, the broker needs to sign. So ever since we came out with this, our members said, this is terrible. Because almost all the time this form is just used to modify a purchase agreement or a lease. What do we need the broker's signature for? And the answer is you don't need the broker's signature then. It's just there if you're modifying a listing agreement or the buyer representation agreement. So it's creating a lot of confusion with officers saying, well, if CAR has the broker signature line, then the broker must need to sign, even if it doesn't affect the broker's own contract. I actually got an email 2 days ago from somebody who was complaining about this. And she forwarded an email that was sent to her where the person said, CAR put the signature line there, it needs to be completed. Like, well, I don't think that's how it goes legally, but it doesn't matter what I think. What matters is how is this being interpreted out in the field. And so last week at the CAR meetings, the Standard Forms Committee said, guess what? We're going to take the broker signature line out. It's creating more problems than it's worth. And we'll just create a separate agenda for listing agreements and buyer representation. Okay, so that's going to be coming out in April. It's there now, but it's going to be coming out in April. All right, so what else can we expect to happen in April? Well, that's Section 4, New and Revised Form 2012, Carbon Monoxide Detector Notice. I talked about it, I said, geez, you don't need to have a carbon monoxide detector as a point-of-sale requirement. It's not a requirement when you sell a property. It's just a requirement for owning property. Legally, it's not a point-of-sale requirement. So what have our members been telling us? As a practical matter, it's become a point-of-sale requirement. Appraisers are saying, you need to have it there. Okay. Which is always kind of interesting because they're appraising the property. And it's not really going to affect the property. It may affect somebody living in the property, no doubt about it. Okay? But it doesn't really affect the property. But anyways, they're calling it up. So, see, a draft of this carbon monoxide detector notice is really just an explanation of the law. Not an allocation as to who's going to pay for it, not a determination of whether it's there or not. And there was a lot of debate in our commission. We changed that notice to make it an allocation. or make it a determination. And the consensus of the standpoint was, no, we're just going to leave it as a notice, as an explanation of the law. That if you really think this needs to be covered as a contractual item, you've got the allocation of cost paragraph in the purchase agreement, right, where you would do maybe tax inspection, who's paying for title, who pays for escrow, who pays for home warranty, that section. And there's 2 or 3 blanks at the bottom. Box buyer, box seller shall pay for blank. And if it's really becoming that much of an issue, then write in one of those blanks, covering the box buyer percentage. And I said, let's just try that out and see how it goes. And we're going to do that. The next one, the office management agreement, that's not going to affect most of you. It's for that new law that requires office managers who are delegating authority to have that authority in writing. Parking and storage disclosure. Simply a disclosure. And what does it say? It's really designed for condos and planned development. And it says, buyer, and it's to be signed by the buyer, it is your responsibility to figure out if you can get your vehicle in the parking spot. Right? If you are allocated a compact spot and you have an RV, don't sue the realtor after the fact. Okay? That's basically what the form says. Don't come crying to me. Check it out on your own. And then finally, the septic well monument addendum. There's a paragraph there dealing with septic inspection. There's a whole variety of things. Is it going to be inspected? Is it going to be certified? Is it going to be pumped? And in the certified section, I have to tell you, there's no uniformity throughout the state as to what that really means. Okay? But it seems to me certain relatively defined things depending on where you practice. Okay? So the issue is, as it's written now, that part of the septic well addendum says, box buyer, box seller shall pay to have the septic system certified. And so the issue is, what if somebody comes out and inspects, says, well, I can't certify unless you do the following repair. What happens then? Well, really, the language as it's now written says, if you check seller to have it certified, seller, you need to fix whatever you need to fix to get it certified. Okay. But a lot of people don't really understand that. And I don't know why, but they were equating certified with inspected, and there's a separate paragraph for inspected. So there was a discussion what to do about that. And the conclusion was to add language that said, if repairs are required in order to get the property certified, basically, I don't have the exact language, basically, buyer and seller shall negotiate. Right, you're exactly right, because you don't know the amount. Okay. So, in effect, now it's treated with the new language effective in April. Really just like we treat the wood pest inspection. You get the report, you figure out what's needed, and you negotiate it out. If you do not use the wood pest addendum. Okay? Like, let's have the information in front of us before we make a decision is really what they're saying. Let's make that clear. I want to finish up, and I'm going to allow time for questions and answers. All right, so there's a whole bunch of cases here. Let me start with E, F, and G. I'm going to start at the bottom. 3 cases about wrongful foreclosure and whether it's possible to undo a trustee sale. Okay? To undo a completed trustee sale. And the first 2 cases, which are interesting enough, involve the same defendant from different parts of the state. Said basically, Once you have a completed foreclosure sale, there's very limited grounds to undo it, to set aside a trustee sale. Part of those grounds is if you lost the property, you were the former owner, you lost the property, okay, you have to tender performance. You have to say, okay, I want to undo the sale, but I'm going to give the money. I'm going to put the money in. And if you don't put the money up, you cannot set aside a trustee sale. Now, these people raised arguments in these cases. One of them said, well, you know what, under California law, a lender has to give this notice before filing a notice of default. The notice says you might have the ability to get a loan modification, basically. Right? It's the pre-notice notice. That's one of those laws that's set to expire things. So the court said, you know what? You can't rely on that law. Let's just assume the seller did not give you the pre-notice notice. That only gives you a right to contest the sale before it occurs, not after the sale occurs. And the other argument that was made is the borrower said, well, wait a minute, I was talking to the lender and I had a loan modification agreement. And then they turned around and foreclosed on me. And the court said, did you bother actually reading the loan modification agreement? You actually had to satisfy the terms of that loan modification agreement. Yeah, you have a loan modification agreement. I'll just give you an example that says, okay, your payments are going to go from $1,000 a month to $800 a month. You actually have to make the $800 a month payment. So just because you're in the loan modification program does not mean the lender is forbidden from closing on you. Okay? And in the last case actually did allow the borrower to go to court to try to get the foreclosure set aside. And what the borrower argued in that case was the loan agreement at its inception was what's called unconscionable. Right? So one-sided, so outrageous that it was unenforceable from its inception. So it was never an agreement in the first place. And if it was never an agreement in the first place, it would not trigger the deed of trust that allows the foreclosure to take place. Okay? People sign things all the time that are not enforceable. Okay? So that was the borrower's argument in this case. Now, I was having a discussion with one of the lawyers at CAR about this case, and I just kind of was glancing through the case this morning, because there's just something about it that bothered me. Okay? And the borrower in this case borrowed $1.5 million and defaulted almost immediately. Okay. And the borrower in this case, where the payments were like $12,000 a month, alleged they only had like $3,000 a month in income. But this was a refinance. So the borrower's already living in this place. Now I'm trying to get this in my mind. So you have a place that's worth $1.5 million. But you have no concept of what you're doing? You already had a loan for $1.25 million. And you refinanced into $1.5 million. Now, and this borrower saying, well, you were taken unconscionable advantage of by the lender. And all I know is, it's a good thing they didn't come to me as an arbitrator. Because I'd say, you know, who are you kidding? And this case, when was it just decided? It was decided December 2011. The default happened in 2007. Okay? Right? Because this way it's to appeal. It takes a long time for things to go through court. There is something in the case that the borrower has been living there this entire time without making a single payment. $1.5 million salary property, but I guess he was duped by the lender. And all I want to know is who's really doing the duping. That's what I want to know.
The borrower did
But the borrower did win this case. The court said, if in fact, they still have to go back to court. I mean, believe it or not, they have to go back to court. Because the borrower said, if the loan was unenforceable in the first place, the foreclosure never should have been allowed to happen. The lender said the borrower signed the agreement. All of the proper procedures were followed to get to the trustee sale. Okay? Therefore, the only way the borrower can try to undo a set-aside for trustee sale is to bring the money into the table. Okay? That's all they were arguing about in this case. Okay? And the court said, well, the borrower does not have to bring the money to the table if the reality was that the agreement was unenforceable in the first place. They haven't even decided if the agreement was unenforceable in the first place. They have to go back to court to decide if the agreement was unenforceable in the first place. Okay? Now, to me, this is a really good decision because it shows the difference between a trial judge and an appellate justice. Because the trial judge basically looked through what was going on. There was even something in here about the trial judge acknowledging that the same borrower has several other foreclosures. The same borrower who somehow doesn't understand anything. So this is the case you have a trial judge who's dealing with the reality of what's going on the ground, right? But the borrower made a good argument, and the appellate justices don't really care about what's really going on. They care about the pure law, right? And the pure law is, if in fact the agreement was never enforceable in the first place, the trustee sale is invalid, and you don't have to bring in the money to do. Okay? So, 2 for the lenders and 1 for the borrower, of these recent cases. You know what? We're going to get to questions in just a minute. I'm trying to fix. I'm just going to pick maybe one more case out of here. One that I like is B. Semler versus GE. Can a commercial lender discriminate against a felon? Okay. So here's the situation. Felon was participating in an LLC that was buying property. The lender was both a lender and an equity investor. The lender is GE. In this case, GE said, well, wait a minute. One of your general members is a felon, and we're not going to loan to you. We don't trust the felon. So they all kicked the felon out. They got the loan. The purchase went through. Felon turned around and sued GE, said unlawful discrimination. You can't discriminate against me because I'm a felon. Okay? Because remember we had the list: race, color, national origin, sex, sexual orientation, gender, genetics, right? The whole list, right? Felon is not on that list, right? But that's it. The law also says any arbitrary discrimination is unlawful discrimination. Okay? So that was the felon's argument. This is arbitrary discrimination. You're discriminating against me based on my class, not against me individually. Maybe my felony was burglary. Or maybe my felony was some white-collar crime. Or maybe my felony was just murder, and how's that going to affect this property? It's an investment, that's all it is. Okay. So, went up to the appellate court. The appellate court said, felons are not protected. Okay? The court said there already exist both federal and state laws that provide that felons can be treated differently from non-felons. And then the court went on to say, felon is not like an occupation or an avocation. Being a felon, although for some people it is an occupation. But the court said it's not a lawful occupation or avocation. So it's not really that way. And it's not a personal characteristic. Although I suppose the next argument would be that there's some kind of mental disability that's causing me to be a felon. And therefore I'm protected under one of those other claims. So the court said it's not like that. And that makes me think, what about other cases where there's categories that are not specifically listed? And then one we get a lot of questions about, get this a lot in the landlord-tenant context. Can a landlord refuse to rent to an attorney? And the attorney's not on the list, right? And some people say, is it arbitrary not to rent to an attorney? Right? And what's the response we most often get? Well, attorneys sue, so it's not arbitrary. And then what happens? You don't rent to the attorney sues, proving the case. So, but I was looking at this case, and I said to myself, it's actually probably a violation of the Unruh Act to refuse to rent to an attorney merely because he or she is an attorney. It's a lawful occupation. Okay? Now, I think it may not be too difficult to find some other legitimate reason not to rent to the attorney. Right? Personality, for some other reason, but merely because the person is an attorney, probably not a legitimate reason, probably a violation of California Unruh Act. Okay, I'm going to open it up.
Okay.
Questions, if that's okay?
So Neil doesn't get heat. I would be the one that selects the person. Do me a big favor. Don't just raise your hand and start talking. Okay? Raise your hand and wait until you're chosen on. Randy first, and then Eva, and then.
Okay, I have a question about intimidation of appraisers.
Yeah.
What, I understand that lenders cannot have any kind of contact with the appraisers, but agents can. And do we have the right to discuss the appraiser's comps with him?
Yeah. You have the right to discuss.
Prior to the appraisal.
Prior to the appraisal, sure. You can discuss comps. You can bring in your own evidence. You can show what's happened. You could say, you could be talking to the appraiser, and the appraiser says, well, I think, this property here is legitimate comp. Okay? That's a good example. I just refinanced my house, recently. I looked at, and I didn't have a problem because I've been in my house a long time, so I'm probably a rarity in California. I have equity. And I was like, I got this appraisal, and like every other person, shocked how low it was, right? And I looked at the comps, okay, well, this comp backs up to apartments and is next to a commercial parking lot. And I'm in the middle of this residential neighborhood, completely surrounded by single family. I was like, how on earth did you come up with that one? As a real estate agent, you're doing a sale, you say, that's not really a proper comp for this property. Let me show you what I think are the proper comps. Okay? You're not bribing. You're not there with a baseball bat saying, let me show you where they're the right comps. Okay? You're trying to persuade. So that's something that's legitimate conduct.
Can we just, if he doesn't want to cooperate or if he's obstinate about it, can we just say, fine, then you're not going into the house to do the appraisal?
It's really not your call as to whether somebody goes into the house to do the appraisal. Remember, it's the lender who selects the appraiser.
That's a good question. It is a good question.
It's more here in the Antelope Valley, as far as I'm concerned.
Good question, but it is the mortgage company that picks the appraisal. I would just say that you're not doing your job if you're not doing everything you can to be there when the appraiser's there at the property, right? Bring your own comps and be there and have a discussion. I think most appraisers would welcome that, okay? Eva.
Husband and wife, both on title, both on the loan, getting a divorce, now already officially separated. Wife makes a lot more money than husband, but that's not the issue. The issue is if she declares BK, do they automatically go after him? And does any foreclosure action that takes place, is that the same procedure as in any other?
Okay, so you have multiple parties on a loan. I'm going to assume that a loan is secured by the real estate.
Yes.
Okay? After it's split, could be a divorce, could be, a separation or partnership, could be a lot of different things. One of the parties needs to file for bankruptcy. The issue is the loan, do payments continue to be made on loan? If the answer is no, the lender has the right to foreclose. Okay? A bankruptcy action stops the foreclosure action, but only temporarily. A lender can, how long is temporary? It really depends on your local court system. It could be 30, 60 days. The lender, it was up to the lender to go into bankruptcy court and get what's called a relief from stay. Okay? Once the lender does that, the foreclosure will continue. Doesn't matter that one of the parties is still in bankruptcy. It is irrelevant.
What if the other party has money, is solvent, lives in another place, and has the capability of picking up that loan?
Okay.
Do they go after the?
Here's the only issue. Is the loan payment being made? If not, lender has the right to foreclose. And can get an excuse from the bankruptcy court to continue. After the foreclosure, is there a right to go after any of the borrowers? And the answer there depends on the type of foreclosure. In California, almost all foreclosures are trustee sales or non-judicial foreclosure sales. There is no right to seek a deficiency following that. So it really doesn't matter that one filed bankruptcy and one didn't. Charlotte?
I have a client, they short sold the house, a first and a second. It actually went through almost a year ago. Now the second is coming back and trying to come after the money after they agreed to short sell the house.
Okay. So, short sale a year ago, before the law went into effect, that said if there's an approved short sale, you cannot proceed against the borrower for deficiency. So the lender somehow approved, the junior lender somehow approved the short sale. What needs to be looked at is the lender's approval letter. Did the lender waive the right to go after the borrower for deficiency? Was there explicit language, as there used to be in many of these approval letters, okay, explicitly not waiving the right? Or was the approval letter silent? Okay? In my view, the only time the lender cannot proceed against the borrower is if there was explicit language prohibiting it. If it was silent, the lender can go after because the law allows the lender to go after. Okay? And of course, if there was language explicitly approving it, the lender could still go after the borrower. You need to look at that language. You can't answer it without looking at it. Yes.
I have two quick questions. I'll take the quickest one first. Is there any stipulation where the carbon monoxide detector has to be installed? I know in the house, but I mean.
CAR has a great article and gives you exact details of where it should be.
Okay.
Away from vents and things, so just go off carbon monoxide, gives you all the details.
Second question. I know that we're not allowed to collect more than 3 months rent for an unfurnished unit. Assuming that's still in effect. Sometimes I get a tenant that, because they have bad credit, offers to give like cash for a year up front. Is that okay to do if it's the tenant's idea?
Okay, so first let's go through what the requirement is. If you're a landlord, you can accept first month's rent in advance, okay, 2 months worth of rent as a security deposit for an unfurnished unit, and 3 months worth of rent for a security deposit for a furnished unit. Okay? But you've got an example where a tenant says, I got terrible credit, but I got a lot of cash. And you say, I wonder what business you're in. But I'm not going to go there now. And say, that's fine. The tenant says, I want to pay a year in advance. Okay? The question is that allowed? Yeah. And the answer is yes. Because there is a specific provision in California code dealing with security bonds that says if you have a fixed term lease that is at least 6 months long, okay, you can collect advance rent as long as you collect at least 6 months worth of advance rent. So then, let's say a tenant comes and you say, I want to pay a year rent in advance. That's great. It's at least 6 months, and hopefully you have a fixed term lease. If you have a month-to-month, can't do it. Let's say you have a year lease, and says, I want to give you 5 months rent in advance. Sorry. I don't know why the law is written that way, but it says at least 6 months rent. Okay.
Good question. Lori?
On Charlotte's example where the second, let's say the second was the purchase money second, on the 80-20 loan.
Mm-hmm.
And then lenders did a short sale, and then they tried to come out them, and this is last year again. I know, even still, a lot of those lenders are going to continue, even if they don't have the right to collect, they're still going to try to come out to you because they sell those loans
to investors, so where they don't care about it.
That's actually a great question. Really, it's a great question because it pointed out how badly I answered the earlier question. Okay? And no, that's great. I'm glad you did that. Okay? Because what did I not cover in the earlier question? That there may be other grounds that prohibit the lender from getting a deficiency judgment. And you pointed out one of those very grounds, which is if it was a purchase money loan. Okay? If it was a purchase money loan. Okay? Doesn't matter if the purchase money was in first position or junior position. The loan was taken out at the time of acquisition and was used to acquire the property. Okay? Lender cannot proceed against the loan.
Good question. Yes.
Yeah, I've got a scenario for somebody that's moving out of state, and they're considering short sale. They have a loan, plus they have a line of credit that was taken after, they got the original loan.
Okay.
And then they would have paid off property in another state. Now, how would that work as far as the line of credit? Can they come after them for the line of credit because they have?
Okay, so then we took a line of credit, secured it by California real estate,
Yeah, it was.
and they used the money. It doesn't matter what they did with the money.
Oh.
They did not improve the property with the money. They did something else with it. They could have bought a car. They could have paid off some other debt somewhere else.
Right.
Okay, and what's happening now? Is there a foreclosure? Is there a short sale? What's happening now?
No, they're trying to consider what they're going to do because the value of the home is, practically nothing now.
Okay.
So they're just wondering, why should they bother and get nothing anyway, and they just go short sale?
Right. Okay. So then their options really are: do they short sale or do they let the property go to foreclosure?
Mm-hmm.
Okay. And here you have a junior lien that was not purchase money loan.
Mm-hmm.
Okay. If they do the short sale and the junior lien holder approves it, and it's residential 1 to 4 property,
Right.
junior lien holder, that's it. You're out of luck. Okay. But if the junior lien holder says, I will not approve it, what usually happens is then the first will foreclose.
Mm-hmm.
Can the junior lien holder then pursue to borrow for the debt? And the answer is yes.
Oh, okay.
Okay.
Did that scenario change if they did use the equity line to improve the property?
Okay. So the changes they did, if they use the equity line to improve the property. There's only one thing that really changes there, and it was the reason I didn't get into that part, and that is there's two issues. There's one is liability on the debt, and the second issue is liability to the government for the forgiven debt if it gets forgiven. Okay? And at least for the balance of this year, okay, if the debt winds up being forgiven, okay, the lender says, I approved the short sale, I cannot go after the debt, therefore it's forgiven, I can't go after the balance, okay, there's actually a tax consequence to that. Okay. But for the rest of this year, if the loan was made to improve the property, there is no tax consequence. Okay, so that's why I was asking that question. It really has nothing to do with continuing liability on the debt. It has to do with whether there's liability to the government if the debt is forgiven.
The tax consequences expire at the end of the year.
The tax consequence for that excuse expires at the end of this year. There's other ways, for example, you could be bankrupt or you can be insolvent where you might get out of the tax consequences anyway. But that specific one expires at the end of this year.
Good question. Kathy, I know you emailed me a question. Do you want to ask it or do you want me to?
No, I can ask it, sure. If someone is a real estate agent and they get evicted, is there a chance they could lose their license?
Oh, the real estate agent gets evicted, okay, well, first of all, it's not a crime to be evicted.
No.
Okay? It's not a felony, it's not a misdemeanor, it's just a civil action.
I just heard that, though.
Okay? So I can't think of a reason why it would be grounds to have disciplinary action by the Department of Real Estate.
Oh, okay.
Okay.
Well,
the question is, what about moral turpitude? I suppose it's possible for the Department of Real Estate to say that is an activity or action that is directly related to your real estate activity. But to me, it's really just a breach of contract. So,
There you go.
yeah, there you go.
Mike, and then I think we've got Lisa.
Okay, I want to go back to the septic. So if you were to put down, like, let's say, cellar, and then you put down, septic tank to be in good operating condition, pumped and certified. So would that be good enough language to basically let them know that, hey, if there's damages, you're going to pay upfront?
Well, if you want to change the language we have in our addendum,
Okay.
you're
No, I mean-
welcome to do so if your office approves, but here's the problem we have, okay? We have a section for pumps, we have a section for inspected, we have a section for pumps, okay? We have a section for certified, okay? Contractually, when you look at the certified, it means whoever is paying to have it certified has to do whatever is required to get it certified.
Right,
But the members did not understand that.
right.
Okay? So that's why we're adding language in April,
Oh, okay.
okay? And the language we're adding is really changing the nature of what our addendum says,
Right.
okay? Because if you just look at the old language, once you check it, you're on the hook, whether it's a $5,000 repair or a $50,000 repair. But
Right.
with the new language, now that we have the number, we're going to negotiate during the inspection period and figure out what to do.
Do you think until April would be a good idea to add that in so everybody understands? Or,
If the language is creating a problem for you, then yeah, you can write something in the clarify.
Lisa.
Question regarding the tax liability of the short sale. I've got a couple clients waiting for their 1099. How long do they have to wait, or do they have to wait? How do they come up with adding that to their taxes to file properly and not getting in trouble?
Okay, so you have some clients who are waiting for their 1099 from the lenders, whether it was a foreclosure or short sale, they haven't got them yet. Hey, guess what? Tax season, things are due. How long do they have to wait? I'm glad to say, I'm not an accountant, so I don't know. So it's really a question for the client tax preparer. You don't have to get a 1099 to have forgiven debt. It could be forgiven, if it was the case of an approved short sale after July of last year, it's forgiven by law. You don't have to wait to get a 1099, okay? Or you got a letter, the approval letter indicates that it was forgiven. It's forgiven. Doesn't matter whether the lender ever gives you a 1099, okay? So I don't think that's the real issue waiting, but it's primarily an issue for the person's tax preparer. I do not know what the IRS requires as proof that the debt was forgiven. I don't know.
And by the way, we have a CPA coming in 2 months to do a seminar. Yeah. Doug and then Claudia.
What I have done in the past on septic is say the seller agrees to pay up to a certain amount to provide certification, and if it's over that, they won't provide it.
Right.
That's okay, right? I mean.
Right, so the comment was, what you did, you simply put a cap in,
Right.
as to the size outside limit. I will tell you, in our meeting last week, that was one of the options that was up for discussion. And that option was rejected at the CAR level, not saying it needs to be rejected on an individual level, it was rejected at the CAR level because we'd like to try to be internally consistent. And when you're dealing with the pest control repairs in the basic contract, you get the number, you negotiate it out. And our experience over time, again, may not apply to every particular situation. Our experience over time is that caps are a problem. And they're a problem for one of two reasons. Okay? The amount is higher, and now you're just thrown back into a negotiation anyway, so why not have your contract say you're going to negotiate it? Okay? Or we also would hear this a lot. The amount comes in way below the cap. And you have a lot of buyers, their expectation was, we are going to extract this amount of money from the seller. And if I can't extract it from the septic, then I'm entitled to extract it somewhere else. Now, legally, is that the case? No, of course not. But the issue is you're dealing with people, and people are human, and humans have expectations. So the collective experience is that caps generally is not a really elegant solution But if it works on an individual case-by-case basis.
And our very last question for Neil is, we say Claudia, and she has the best question of the day. No pressure, right, Claudia? Claudia.
In a short-term transaction, the new owner of the property can rent the property to the, previous owner?
Ah, that is a good question. In a short sale, can the new owner rent the property to the previous owner who sold the property in a short sale? And the answer is you need to look at the lender's approval terms. And I think you're going to find that most of the approval terms will prohibit the seller from continuing to live in the property. Doesn't matter in what capacity, they're going to prohibit the seller from continuing to live in the property. Okay? So, now if spontaneously, after the close of escrow, the buyer and seller happen to mutually come to an agreement that they never even considered during the short sale process, they could say our intent was not to defraud the lender at that point in time. You still need to look at the language, because if there's an absolute prohibition, then it's a violation. If it is a prohibition that's tied to the sale, well, then maybe one could argue, but not. And the reality is, most lenders don't do anything about any of this stuff. Okay? A good example, I was speaking to a realtor friend of mine this week, and we were talking about short sale fraud. And this person is very involved. She's a manager for a big company. She does a lot of education. She deals directly with a lot of the lenders. We're talking about short sale fraud, and we're talking about a particular lender, and she says, between you and me and anyone Neil shares it with, this lender just flat out doesn't care about fraud. Of course, I'm not telling you who that lender is. But I think that's a common experience, that they just want to get the property, off their books. They want to get their money. They want to get it sold. They don't want to deal with it anymore. They may have the legal right to pursue the principles. And the issue is, there's the business judgment part of it. Remember we were talking about business judgments earlier on? There's a lot of things you can do or you can't do legally, and then you make a business judgment as to how to proceed. I think a lot of these lenders are making the business judgment. We may have a legal right, but it's not worth our effort to pursue that legal right. So the legal answer is probably not, because there really is no such thing as a spontaneous after closing agreement between the buyer and the seller. That's just not reality, okay? The issue is, how much risk are they willing to live with? Okay?
Can I add to that just real quick, gang, okay? One of the principles here is integrity. What comes after that? Do the right thing. So all I want to mention is this. Don't you ever get in a position where you're saying, you know what, that's against the contract, it's against what the bank said, but I'm advising you to go ahead and rent to that person, because they're probably not going to come after you. Not your place to say it. What your place to say is what the contract says, what the right thing is to do. If they make a different decision than what you told them, that's their decision, but you are never involved in that decision, right? You're never involved in advice on that decision, okay? Not your job, not your place, not the right thing to do. And, one thing I love about this is, first of all, I got to tell you that April and I, if we try to get this game to sit still for 20 to 30 minutes, not happening, okay? But Neil can get you guys to sit still for 2.5 hours. And when you're talking about legal things, you think it's going to be dry and boring, but he does such an amazing job of presenting the information. And, there is going to be a tip jar over there for the comedy. And he's here all week. Okay? But I just so appreciate the way he delivers the information, not just the information, and it makes it so that we can remember and use it, okay? So use this. I'm so proud of you that you're here, because I know that you want to do the right thing. You want to be very, very professional realtors, and I applaud you for that. Let's applaud Neil for bringing us in. So Okay, also want to highly recommend that in your cell phone or on your desktop, you have the car legal hotline, okay? Because there's going to be times where maybe you can't get a hold of me, or many of you have come to me with a legal question. I said, I'm not really sure about that. I believe it's this, but call Car Legal. And here's what I want to help you to help me, is when you run across something that you know will be helpful to somebody besides just yourself in this office, get the answer and then send it off to me. And I will share it with the others in this office. And between all of us, as we get those legal answers and the information, we can share as a team and grow as a team, and we become more professional, okay? So we'll work on it. I'm here to answer your questions. You know that we are. Amy is, April is. We're here to help. And we have that great tool of Car Legal, and the car website is amazing. Everything is on there. So at any rate, we have lunch sitting out here, free lunch to everybody that attended the meeting. I thank you very, very much for coming today. Go out, make it a great day. Thank you very much for coming. Have fun.